APUS government students, here is your exam 3 judiciary review in 10 minutes or less. So it's important to take a look at this slide both in your notes here and in the notes later to make sure that you understand the path a case could go to the United States Supreme Court. We talked about that path either being on the left or the right in terms of starting at the federal district trial courts or the Nebraska trial courts as jurisdiction. So where would the jurisdiction lie, with the states, in our case Nebraska, or with the federal court? So we'll talk about that here in a bit. So starting at the bottom, moving up on the left or moving up on the right. Again, then look and see that we adopted this system from the British, the desiring of uniformity, the precedence, the standing on decided cases, equating to stare decisis. So sources of American law, there's going to be a question, where does it come from? So there's that English common law tradition, so make sure you get that correct. And it has its basis in that common law tradition and stare decisis and precedence to stand on decided cases. The idea of, if someone cheats on exam 3, I give them a 0. Someone cheats on exam 4, stare decisis, the common law tradition, would require me to stand on that decision in exam 3, that precedent that I set, to give that person a 0 on exam 4. The real basics of this slide is the idea of Congress controlling much of what's enumerated to the judiciary. Congress is given a lot of power over them. Lifetime appointments, I'll talk about that here in a second. But I would also go back and look at real quick the answers to document dive number 4. There'll be a number of questions about the Federalist number 78. So make sure you understand those questions that I asked, because you're going to see them on the test. Just a simple basis of this slide is just showing you kind of that hierarchy of laws in the Constitution and recognizing that everything must follow the Constitution. All of the things below those arrows must follow the Constitution or must be thrown out. And what gives the courts the power to throw those things out is this important court case called Marbury versus Madison. There was no check and balance in terms of judicial review in the Constitution. It was created by this very important, vital court case of Marbury versus Madison. So the courts in this case, the Supreme Court in this case, and Chief Justice John Marshall, looking at a federal law, believing that it violated the Constitution, and then pronouncing this idea that it's their job, the judiciary's job, to be the safekeepers, the safeguarders of the Constitution. And this law cannot stand, so they say. It violates the Constitution, in their opinion. And because it violates the Constitution, in their opinion, it cannot stand. It must be voided. It must be thrown out. And this is known as judicial review. Though they created in Marbury versus Madison, it was first discussed in the Federalist number 78 by Hamilton. Lecture 2 then, again, this is that look at the structure of cases moving up. I will make note of the slim chance at getting to the U.S. Supreme Court, top left, and then there'll be a question about if there is a reversal. It's usually of state laws. You can see that there, top right. We went over this. You should have the answers to this. We looked at a little snippet from Boston Legal. Then we took a look at jurisdictional keys. All right. So if a case and its issues have things there in the red on the left, it has to have one of those 3, of which we talked about 1 and 3 being the big ones, 3 being the biggest one. If it deals with a federal law, the U.S. Constitution, and the amendments, or the amendments, I should say, it can get into federal court. All right, so those are jurisdictional keys that we talked about and looked at. If they don't have one of those three keys, it has to go through the state level. All right, so this gives you the idea of where a case starts, left or right, federal side or state side. We then talked about the idea of federal courts of appeals, the Nebraska Supreme Court, and the U.S. Supreme Court. They do not retry cases. They do not retry cases. They will look at interpretation, procedure, was it done correctly? And then they will make a determination based upon what they see of that record on those two issues. One of the big things that we looked at in this chapter was this slide, so make sure you understand this. We talked about activism and active role of throwing out laws, utilizing judicial review, others using it in a much more restrained role, restraining themselves from doing this. Because as you can imagine, utilizing judicial review and throwing out a law is controversial. It was passed by a state legislature or it was passed by the Congress. So that's a big deal in terms of utilizing judicial review when judges and courts do this. Keep that separate from strict versus broad construction, so make sure that you lock in the difference between this. This is now the idea of how do they look at the interpretation of laws. Do they lock in that meaning forevermore when it was written, strict construction, or do they allow that meaning to evolve over time, look at the intent and purpose of that to make their decision? So Obergefell versus Hodges, so make sure you take a look at that quote, those quotes on 42 and 43 in your blue packet. That, in the opinion by Kennedy, is classic broad construction. Scalia, in his dissent, their opinion of the disagreeing justices, that is strict construction. We look at what Scalia wrote versus Kennedy. Then we looked at a couple of issues. All right, so if you want to pause it here and read those, you can do that now and then decide activism or restraint or strict versus broad construction. The top is judicial restraint. The bottom is strict construction. So take a look at, Obergefell versus Hodges as well. We did not go through this in class, but I'll give this to you here quick. This case is going to start at the federal trial court. Because it deals with the Fourth Amendment, it has federal question jurisdiction. That is eighth. The power to hear a case is called jurisdiction. This case is then on the left-hand side. So where does it go next? The Eighth Circuit, and you can just tell me Court of Appeals, but specifically it would go to the Eighth Circuit. Number 10, strict construction. Number 11, interpretation and procedure. All right. The selection of federal judges by the president. So make sure that you recognize that. We talked about senatorial courtesy just with the federal district trial court. The senators of that state where that opening is working with the president to help fill that vacancy. They do not, the senators do not have exclusive control, but they try and work with the president and his team to be able to find a workable name for that vacancy. Then we talked about the Federal Court of Appeals. So this is where they get a lot of ideas for future Supreme Court justices. Then we looked at the factors in terms of what the Supreme Court looks for justices, what they look for in cases for them to hear or not hear a case. Disagreement, we looked at that, importance, and significance to the executive function. So if you don't understand this, make sure you talk to me about this. And we also did that activity that dealt with this 3B. So if one of those factors is present, they're going to issue a writ of certiorari. Recall 4 justices must agree to do so. And it's a very, very small amount of cases that they will hear and issue writs of certiorari. We looked at amicus briefs, those filed by people that are not a part of the case, and them being filed with the court, their impact maybe or maybe not upon those decisions. But again, these are people that are not a part of the case. For example, the Papillion La Vista Community Schools looking and providing a brief on the Bong Hits for Jesus decision. They're not a party to it, but they feel like it would impact their schools, so they providing an amicus brief. Finally, then, as I'm getting a little bit long, make sure you take a look at this here on number 10. There'll be a number of questions on multiple choice about this slide and this slide, the checks and balances on the judiciary. So I went just a little bit long, but make sure you stop in and you see me if you have any questions on Wednesday morning to get ready for the test for exam 3.